The U.S. Supreme Court on Tuesday appeared closely divided along ideological lines over whether Congress had the power to require most people in the United States to buy medical insurance, with conservative justices asking skeptical questions about President Barack Obama's healthcare law and liberals defending it. During 2 dramatic hours of arguments, pivotal justices on the 9-member court suggested they would uphold the so-called individual mandate requiring people to obtain insurance only if they believed they were not giving Congress broad new powers over people's lives. 2 conservatives, Scalia and Samuel Alito, were vocal in their skepticism about the validity of the requirement. Scalia, in particular, seemed concerned that Congress and the federal government would have unlimited powers if the law was upheld.
The argument here is that this also is maybe necessary, but it's not proper because it violates an equally evident principle in the Constitution, which is that the federal government is not supposed to be a government that has all powers, that it's supposed to be a government of limited powers, and that's what all this questioning has been about. What is left? If the government can do this, what else can it not do?
Chief Justice John Roberts and Justice Anthony Kennedy, 2 conservatives who could join the 4 liberal justices to uphold the law, pressed an attorney for the Obama administration to say where the limits would be on federal power if people who opted against insurance were forced to buy coverage. Roberts and Kennedy also raised to the 2 lawyers challenging the individual mandate the government's contention that Congress is validly regulating people who are already in the market because virtually everyone is going to need healthcare at some point. Kennedy said young, uninsured people affect the overall market not by paying into it and ultimately receiving care over the long term.
In the insurance and healthcare world, both markets, stipulate 2 markets, the young person who's uninsured is uniquely, proximately very close to affecting the rates of insurance and the cost of providing medical care in a way that is not true in other industries. That's my concern in the case.
The 4 liberal justices all indicated that they believed the mandate was valid under the U.S. Constitution. The 9th Justice, conservative Clarence Thomas, who is expected to vote against the law, asked no questions. He has not been asked a question from the bench for more than 6 years. A decision by the High Court, expected just as the presidential and congressional campaigns will be moving into high gear, will likely be a flashpoint leading up to the November 6th general election, no matter how the court rules. Marisa Christian, IB Times TV.